Hi, everyone. So today I am going to be answering your questions, right? You always ask me questions in the comments, and I am going to be answering those today. If you are joining me live, please put your questions in the comments so that I can answer them for you. And if you're watching this on the replay and you have questions, put them in the comments. I always go back and respond to those questions. And I am going to be turning these Q&A sessions into a series where we do a Q&A session every last Friday of the month. So that way, when you have all these questions in my comments on YouTube, Facebook, I will be able to basically put them all together and answer them on the last Friday of each month. And of course, if you watch my videos in between, if you watch my lives in between, and you have questions and you put them in the comments, I will be responding as well. Hi, Bineta. I'm sorry, Binta. Welcome, welcome. Good morning. Hi, Wilma. Happy Friday. Thank you so much for joining me. And like I said, if you have questions, put them in the comments. That's literally why I have these Q&A sessions so that you can ask me your questions and I can give you an answer. Okay. So I'm going to start off by introducing myself in case you don't know me. I am a U.S. immigration attorney. I'm Lillian Chukura. Most people just call me Attorney Lily. That's fine. And I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So if that's of interest to you, if you would like to learn more about US immigration, green cards, and citizenships, then this is the channel for you. Please do subscribe, comment, like, all of the YouTube things. And if you would like to get a strategy session with me where we go over your particular case and figure out what you qualify for and all of those good things, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. All right, let's get into it. Remember, if you're joining me live, please, please, please ask me questions. All right. And say hi as well. Now, the first question I have here is if I am permanently changing my physical address, traveling and visiting friends across Europe, do I need to inform USCIS each time, even if I change countries one time per week? If so, how should I inform them? So there was a lot there. One, if you are filing a petition with USCIS, you need to update them every time you permanently change your mailing and physical address, right? So that means a permanent change. So if you're traveling from one country to another, within a week, is that really a permanent change, right? So if your permanent address has not changed, you're just traveling the world, that's fine. But if your actual home address has not changed, it's just that you're traveling, you don't actually have to update USCIS every time you go from one country to another, traveling and visiting friends. However, if you are permanently moving to a new address, to a new country, you do have to change that address with USCIS. Now, if you are outside of the US and you are the beneficiary, meaning that someone in the US is filing for you, like filing an I-130 for you, your address doesn't really have to be changed, only the petitioner's address has to be changed. However, when you get to the National Visa Center stage, that's where you do your change of address, okay? So just keep that in mind. If you're not the petitioner and you're not living in the US, you're most likely not going to have to change your address until you get to the National Visa Center stage. If you have not changed your permanent address, so your permanent physical address, your permanent mailing address, you do not have to update USCIS, okay? The reason they want you to update them is so that if they send you mail, you cannot say you never received it because they're sending it to the address that you told them they can find you at. All right. Let's see. The next question is from Wilma. What happens next when I-130 for minors is approved but live in the Caribbean? Oh, perfect question. So when the I-130 is approved, it is sent to the National Visa Center. So USCIS approves it, it's sent to the National Visa Center. From there, you pay the visa fee, and then you will complete a DS-260 and an affidavit of support if it's required, right? And then you'll upload the documents to prove, birth certificate and all those things that's required. And then after that, the National Visa Center will tell you once they have all your documents, right? Once they have reviewed everything and they're like, we don't need anything else from you, we're going to put you in line for an interview. So that's the next step after that. And then you wait for the interview to be scheduled and the kids attend the interview. If the kids are minors, like you said, they will need an adult to go with them. And if that adult is not a parent, then you would need to have a power of attorney for that person that will be going with them. Okay, so that is the process from here. Congratulations, you're on your way to having your kids with you. So that is great. Binta asks, I received a letter to do medical exam. If my green card will be waived. Okay, so right. So basically, what used to happen is USCIS will process your green card application, send it to the field office. The officer at the field office that's going to make the final decision on your case reviews your file. And once they find out that they have everything they need, they don't need an interview, they will go ahead and request your medical so that they can actually go ahead and approve your case. Now USCIS is trying to be even more proactive, where when the case is at the service center, before it gets to the final officer that's going to make a decision, they are requesting the medical. So here is what you need to do. On the request for evidence for the medical, you need to look at what address are you sending it to, right? What address do they want you to send the reply to? Are you sending it to a service center, the National Benefits Center? If it has a center in the name, right, that means it has not reached the final officer that's actually going to make a decision on your case. All right. If it has the field office, so your local USCIS office, that where you would actually have an interview, if an interview was to be scheduled, if that's the address on it, then you will go ahead, in those cases where it's the field office, that means the chances of your interview being waived is higher, right? It's more like 90% it will be waived. But if it's at the service center, it doesn't really mean anything. It just means that they're being proactive and just getting all the documents for the local field officer once the file gets to them. Okay. All right. All right, another question. My I-130 just saying sent you a receipt notice and acceptance notice. The notice describe how we will process your case. Yes, so that is completely normal. So when you file an I-130, I'm guessing you filed an I-130 with an I-485, the green card application, at the same time, right? The medical is required for your I-485. So the green card application requires your medical. So when they're requesting evidence and requesting that medical, it's only going to update on the I-485 receipt notice. So when you do the case, when you search for the case update and you put the receipt notice for the I-485, that's where you will see that update that is asking for, there's a request for evidence. The I-130 doesn't really need that. So it will still say, we accepted it. We sent you the receipt notice. If we need anything, we'll let you know. Okay. At this point, it just means they don't need anything from you for the I-130. They only need the medical for the green card application. So you're fine. Okay. Okay. So at this point, you're fine as far as the medical is concerned. Oh, all right. Another question. What is time frame in response from MVC and interview time frame? So this is where things get a little tricky because the time frame is really dependent on the country. So each country has an embassy. The embassy has their own time frame. There's no general time frame. With the national visa centers, depending on when the case was approved by USCIS, typically within a month of approving the case at USCIS, the file is sent to National Visa Center. Once they receive it, typically within a week or two, they will send you a notice saying, we've received it, here's the case number, here's the invoice ID number. That's when you start making the payment, uploading documents, filling out the DS-260, the affidavit of support, and all of those things. However long it takes you to do that, that's really on you. All right. But once you have uploaded everything and submitted everything, typically within a month or two, National Visa Center will let you know if they need anything else or if you're good. Once they let you know you're good, that's when it really becomes an embassy time frame, right? Excuse me. That's when it becomes an embassy time frame. So depending on the country, the time frame can be a year, and in other countries it's more like 2 to 3 years. So I would check with your specific country's embassy to see how long it's going to take there, right? Ooh, sorry about that. Binta, you are so welcome. I'm glad I was able to answer that question for you. And then for anyone else, okay, good for you. Well, you should be fine as long as there's no major issues in your case. But our number is right on the screen, actually, right next to my name, the 508-443-1788. That's my office number. All right, Wilma. For minors, yes, the time frame is the same. The time frame for adults and minors are the same. There's not really much of a difference, as long as they're. I'm not. It's not clear if you're a U.S. citizen or a permanent resident, but even if either one, you will have the same process. So let's say you're filing for a spouse of a U.S. citizen or a minor child of a U.S. citizen, the processing time is the same. Okay. That's really what that comes down to. So even though they're minors and even though it should go faster because of their age, USCIS, National Visa Center, Embassy doesn't really make that distinction. Okay. All they look at is what category do they fit into. All right. If they fit into immediate relatives of a US citizen, that's the category they fit into, and that's where they're put in. As far as when they're going to have an interview and all of that. All right. So if you're just joining me and you have immigration questions, please, please, please feel free to put them in the comments. I am more than happy to respond. This is your time to ask me your questions. All right. You are very welcome, Wilma. Let's see. So while I'm waiting for questions to come in, I'm going to be answering other questions that were previously submitted. Okay. So someone asked, can a U visa applicant be outside of the US and apply for a U visa? And can they apply for their children? How old do the children have to be? So a U visa applicant can apply from outside of the US as long as the crime right? The qualifying crime took place in the US. So basically, if a crime was committed against you, let's say you're visiting the US, and a crime was committed against you here in the US, and you cooperated with the police, prosecutors, and all of that, but you left the US after the fact, you can still apply for a U visa because the crime took place in the US and you assisted in the prosecution or investigation of the crime, right? As far as children, children have to be under 21 and unmarried, okay? So your own children that are under 21 and unmarried can be included as derivatives under a U visa application. For those that don't know, a U visa is for victims of crime, the specific crimes if you are a victim of in the US and you helped the police, the prosecutors in the investigation and or the prosecution of the crime of the perpetrator, you're able to get a certification, apply for a U visa. It is a long process. However, it is an option for certain victims of crime. Okay. Let's see. All right. So this came from a video. This next question came from a video I did about how to win your marriage case and what type of documents you need. So basically, this person is asking, what if we live in the same state but different county because my spouse has a child in high school and we don't want to change the school? So it won't disorganize the child, but we do most of the finances together. And I'm in my spouse's apartment more than my own. We're saving to buy a house. So, like I always say, USCIS expects married people to live together, especially when you live in the same state to start with, right? If you two got married and you're living in separate states, and you're just, finalizing yourself to move to your spouse's state, USCIS understands that, but it's not like it's taking you a year to finalize and move. So if it takes you a month to finalize everything and move in with your spouse, that's fine. But if you live in the same state, just different counties, USCIS will want a really good reason why you're not living with your spouse. Okay. So in this person's situation, they're saying the reason is there's a child involved. The child is in high school. We don't want to move this child out of their school. The question the USCIS officer is going to have in this situation is, okay, so your spouse can't move because of the child. Why can't you move in with your spouse and the child? Right? That's the question USCIS is going to have. So unless you have a really good reason why you can't move, right? You've given a reason, right? This person gave a reason why the spouse can't move in with him, but not a reason why he can't move in with the spouse. So unless you have a good reason why you can't move in with your spouse, yes, you're there all the time. However, USCIS still wants to understand why you're not residing in the same address. Okay. So just be careful with that. So even if you think you have great reasons, I still suggest moving in together as soon as possible. Because that's just going to help strengthen your case versus not moving in together and USCIS raising that as an issue. All right. All right. So another question. Can you file for citizenship after 3 years of marriage or 3 years after obtaining permanent residence? This is a great question. All right. So if you get your green card and you're married, it's 3 years of having your green card, not 3 years of being married. Okay, so citizenship, this is a great question because a lot of people get confused because they're like, oh, it's based on marriage and there's 3 years. So which one is it? So it's 3 years after getting your green card. As long as you're still in a marital relationship with your spouse, you're able to then apply for permanent residency. Okay. So it's not 3 years after marriage, because then, and if you wait 3 years before you file your green card is approved, you can immediately apply for citizenship. So that's why they made it 3 years after getting your green card. Thank you. All right. So this next one is from the video I did about parents that enter the U.S. without a visa and how they will need a waiver if they want to get a green card through their children. Excuse me. And the waiver requires them to have a U.S. citizen or permanent resident spouse or parent. So this person is asking, what if the grandparents, so their parents' who is the qualifying relative for the waiver, is deceased? So in this situation, unfortunately, they will no longer qualify for the waiver. So if the parent is the qualifying relative for the waiver, they will no longer qualify once the parent is deceased. That is not the same as if the spouse is deceased, right? When the spouse is the one that passes away and the spouse was the qualifying relative for the waiver, then USCIS has a presumption of hardship in those situations. However, when it's a parent that passes away, then it's unfortunately they would no longer qualify for the waiver. Thank you. Okay, so great question, Wilma. So basically, if you're filing for citizenship based on 3 years of 3 years of residency, because you're married to a U.S. citizen, you may be required, right? So it's not 100% one way or the other. Excuse me, y'all. You may be required to attend the interview with your spouse. May be required. However, what is necessary if you are going to be filing in 3 years is to include proof of your relationship, right? Proof of your continued relationship with your spouse, right? But if it's the 5 years, so if you wait 5 years, there's no requirement to show proof of your continued relationship with your spouse. You're just filing for citizenship based on having had your green card for 5 years, right? So then there's no additional requirement of showing that you and your spouse are still married and still in a marital relationship, okay? All right. So this next question is about, so this person basically saying that I want to upload additional documents to USCIS for my marriage-based green card. However, I heard that I shouldn't upload it, but I really want to upload it. So here's the thing. Once you file your green card application, if USCIS needs anything from you, they're going to ask for it, right? They have a whole process called a request for evidence that if they feel that they're missing something, they're going to ask for it. And yes, even if they're trying to decide whether to waive your interview or not. So let's say the file is in front of the officer and they're like, you know what, I may want to waive this interview, but I need additional documentation of the relationship. All they have to do is press a button and send that request for evidence, okay? So that's when you will send them additional documentation. If you send additional documentation without a request, depending on how you send it. So if you send it in the mail, sometimes it doesn't make it into the file, and then you get to your interview thinking that they already have it, or you're like relaxed thinking they already have it and they don't, and then you still get the request for evidence. So typically, what I do for my clients is go ahead, create a folder, right? Either a physical folder or a digital folder where you're saving your bank statements, your lease, your payments, like anything that you would want to include in a response to USCIS to prove your relationship. Go ahead and create a folder, put it in there, and save it so that if they send you a request for evidence or they send you an interview notice, you can just take that folder, print it out if it's digital, and take it to your interview with you, or mail it to you, or send it to USCIS as part of the request, as part of your response to the request for evidence. So it's not always a good idea to send the documentation without a request for evidence, because sometimes it gets lost and the officer may not see it and still send you a request for evidence. Okay. All right. So someone asked on a VAWA video I did, someone was asking, what if you have been abused in the workplace? Well, VAWA is for abused spouse, child, and parent of U.S. citizen and some permanent residents. Okay. If you were abused in the workplace, there is certain visas available for that. Okay. The visas that are available for it is a T visa or a U visa, depending on if the crime was reported and all of those things. If you assisted with investigation. However, most of the time, abuse at work, when you're trying to get immigration benefits, is going to be under the T visa. The T visa is for labor trafficking, and it's basically for trafficking, the general umbrella, but labor trafficking is under that as well. So abuse at work may fall under labor trafficking, so that would be an option. Okay. Okay, so that Binta, that is the service center. So that is not the field office. So unfortunately, the file is not already in front of an officer, but USCIS is being proactive. So once it is in front of the officer can quickly review everything and have everything they need in order to make a decision. So it's going to make the process smoother, where they're not having to send you a request for evidence and waiting for that to come in. They can just look at your file once it gets to them and make a decision. Okay. And again, that decision may be, we're going to approve your case, or that decision may be, we're going to schedule you for an interview. Okay. But either way, once they get your file in front of them, they will be able to actually make that decision at that point. All right. All right. So this is a bit longer. So how about when you have a student visa, you travel abroad for school, did one semester but didn't complete, and went back to your country? Can you visit the USA anytime, or what's the outcome? So you would, depending on the country the person is from, right? And how long they stayed in the US after they stopped going to school. So if they just did their semester, the semester ended, and they left the US, right? Then that's fine, right? That's completely fine. If they want to come back to the US, though, they will need a visa. So if they're just coming for a visit, they will need to apply for a B1, B2 visa, depending on the reason for their visit. And that would need to be approved before they can come back to the US. So they can't come back to the US with the same student visa if they're no longer in the school, right? If they're no longer attending classes, they can't come back with the same student visa, but they can apply for, they can still apply for a visa to the US, okay? All right. So if you're joining me, hi, welcome. If you have a question about US immigration, please feel free to put them in the comments. I am more than happy to respond. And if you are watching this on the replay and you have questions, put them in the comments. Like I said at the beginning, this is going to turn into a series where every last Friday of the month, we come together and we do a quick Q&A, and I get to answer your questions, okay? So feel free to ask me your questions. All right. Okay. Danielle asks, if I am petitioning for both parents at the same time, do I need to pay for the affidavit of support twice? Yes. I'm sorry, but yes. The only time the affidavit of support, like, yeah, you do have to pay for it twice. Typically, if it's like a parent child, or when the child is a minor, um, that's when you may be able to just pay for one person and not the other. But when you're filing for two separate adults, you will have to pay for that twice. Okay. And then Wilma is following up with her previous question about the student visa um, person. Even if the visa was for 5 years and still valid, yes. So here's the thing. You can have a 10-year visa to the US, right? But you still, every time you come into the US, you still have to prove to the officer at the airport that you qualify for that visa, right? So if the person has a student visa, they only did one semester, they left the US, and they are not currently in school, they're not, following any of the things that they're supposed to do as a student visa holder, which requires you to attend school, to maintain your, to have a full course load and all of that. When they're coming into the US, even if they have that student visa and they're coming back into the US, they need to have a valid CIVIS account. Okay, so every student visa holder has a CIVIS account, and USCIS at the airport can CBP officer, I'm sorry, at the airport can easily look up their CIVIS to see if it's still active. If it says that it's no longer active, especially if they just did one semester and left, most likely the school has terminated their CIVIS. Okay, so if it's no longer active, then they can't enter the US with a student visa, because you're required to have an active CIVIS account to be on a student visa. So even if they still have 5 years and it's still, even though it still says 5 years, when they're coming in, that's when they're going to have an issue at the airport. Okay. All right. So I'm just going to see. I think I may do one more question before I go. Mm, okay. So this person asks, can I apply for an adjustment of status for my husband if I'm still waiting for an amended tax return? They say it could take 5 to 6 months to process the amended tax return, but his extension expires in July. All right. So I did answer this question in comments. So they're not waiting until now to hear a response. Basically, yes, right? You can still file with your amended tax return pending. So basically, when you file an amended tax return, you should have a copy of the tax return itself, right? While it's pending. Just like if you file your tax return, right, on on April 7th, you go ahead, you file your tax return. Your tax preparer is going to have a 1040 for you, and you can use that 1040 to show that what your income is and all of that. Okay, so it's the same way. Even if you file an amended return, you still have a 1040 that's generated from that amended return that you can use to file for the affidavit of support in when filing for a spouse. So a copy is enough while the IRS is processing the tax return. That's your proof of filing. All right. All right. Elizabeth is asking, is it right to call the immigration about your petition? It's taken. Oh, okay. So it's a two-part. So is it right to call the immigration about your petition if it is taking long time before hearing from them? So it depends. You can call USCIS. They have an 800 number that you can call them on. However, what you do want to do before you call them is check your case processing time. Okay, that's really important, because if you, let's say the normal processing time for your case is 15 months and it's only been 6 months, they're just going to tell you that it's within the normal processing time. However, if you check the processing time and it says that the normal processing time for your case in your location and everything is, let's say, 15 months and it's been 20 months, then calling them will make a difference, because then they can do a service request to find out what's going on. However, if it's still within the normal processing time, they're not going to do anything. You can call them, they're not going to do anything. However, if it's past the normal processing time, then you will be able to actually get a response. Okay. You can check your processing time on the USCIS website. If you scroll down, I have a video on how to check your processing time. It's on the guides. So go ahead and look at that and check your processing time. And then now they have a section where you can put the date that you filed your application, and it will tell you when you can call USCIS to start asking them for a service request. So they have even made it a little smoother to figure out when you can call them for a service request. Okay, so check the processing time, check when you can call them, and then if it's within that time frame, call them. It is they will put in the service request to see what's going on. Why isn't their decision made? It's just, sometimes, most of the time, they may come back to you and just say, we're still processing your application. We don't need anything from you at this time. You may get a decision from us, or an update from us, or a notice from us in the next 60 days. Right? That may be the response you get. And then you wait for the 60 days. If there's no movement, you just repeat the process again. Okay? So that's what you can do as far as calling. And then another tip is, if it is past the normal processing time, you can always reach out to your congressman or congresswoman and find out if they can help you get an update, right? So that's something, depending on how long it's been, how long past the normal processing time you are at, you're able to reach out to your congressperson and get them to at least reach out to USCIS on your behalf. Okay. So that's an extra tip if you stayed all the way to this point. And then I don't see any other questions. Thank you all so much for joining me and asking amazing questions. Okay, a lot of people watch, right, and they have the same questions you have. They just may be shy to ask, but thank you so much for asking. People are really going to get a lot out of this. So thank you. As always, I am Lillian Chukwurama, US-based immigration lawyer. If you would like to get in touch with me and schedule a strategy session, you can do that by going to my website, lilylegal.com, or calling my office at 508-443-1788. And as always, I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Thank you so much and have a great rest of your day. Bye.